Hello everyone, my name is Natalia and I am a real estate attorney here in the state of Florida. And today I wanted to talk to you about the Uniform Commercial Real Estate Receivership Act. So this is a brand new piece of legislation that just got enacted last summer, but a lot of people have kind of ignored it, not been aware of it, so I thought I would have a little conversation with you guys about it. And today I want to tell you the 4 most important things that you should know about this act. So what is a receivership? What is a receiver? So a receiver is a court-appointed person that takes possession of non-homestead property. So it could be like a commercial property or pieces of residential property that are not the homestead of the person who is in trouble with their lender. And the receiver takes care of it and operates it during foreclosure proceedings. So this receiver used to be a process that was very case intensive, case detailed, and each particular case, if they requested a receivership, kind of went by the seat of its pants. The rules, regulations, the authority that the receiver had was based on whatever the proposed drafted order was that was submitted to a court. And so it was very unpredictable what would happen with your property if it went into receivership. So now the receiver has specific powers that have been granted, and these are the 4 things that I want to discuss with you today. So number 1, the receiver has the ability to operate the property during foreclosure. And what does that mean? It means that they can rent it out. It means that they can run the business that's there. So they can order supplies and pay the vendors and pay the employees and essentially manage the business on behalf of the owner. The owner has to turn over control to the receiver, and it has to produce records to the receiver. And the failure of the owner to operate or to turn over control of operations or to turn over those records can actually result in civil contempt proceedings. So if you have a commercial property and you've got a loan on that property, be aware that a receiver can be appointed to essentially take over your business that you have there. So number 2, the receiver can sell the property prior to the entry of a final judgment of foreclosure. This is huge. This is very different from what we had before because generally in Florida, in order to have a sale that is forced pursuant to a delinquency in a mortgage, you had to have a final judgment of foreclosure that ordered a sale date, and then there was a public auction held. In this case, the receiver can actually sell that property prior to. Either the owner can consent in writing, going along with that motion that's submitted by the receiver, or the owner can be given reasonable notice that there's a sale that's coming up, and if they fail to object timely, that sale is going to take place. So it's very important for you to know that, again, if you have borrowed money to purchase or maintain your commercial property, refinance it, whatever it might be, a receiver can sell that property in advance of any final judgment. So number 3, relating to the sale. Okay. The receiver has been given kind of bankruptcy authority over things. So if that sale takes place, that sale can actually state that it's selling property free and clear of any liens. This is huge if you're interested in purchasing commercial property from receivers now, because you're going to be buying it free and clear of any liens, so long as the order directing the sale directed that it would be free and clear of any liens. Simple as that. What happens to those liens? Well, those liens attach to the sales proceeds, just like if it was in a bankruptcy proceeding. And then you're probably wondering, okay, what happens if somebody appeals the sale? Is it going to be undone? Am I going to be in trouble? What's my title going to look like? Fortunately, they've written it to the statute that an appeal that results in a reversal or modification of the sale order will not undo the sale or invalidate the sale so long as the purchaser was a bona fide purchaser, so like a third party disinterested to the other parties relating in the transaction. All right, so number 4, the final point that I wanted to make regarding receivers. Receivers have this other additional bankruptcy-like power in which they can accept or reject executory contracts. What the hell is an executory contract? Well, I'll give you an example of an executory contract. A lease, a commercial lease, it's an executory contract. And so the receiver, when they take over control of this property that's in foreclosure, they can literally take a look at those leases that are there and say, yeah, we're going to reject all of these. These are just, they're gone. Like, we're going to terminate these leases, moving on. Or they can accept it and say, yep, we're taking over this, you know, like the rent will be cut over to me as receiver to administer this and make sure that the lender is getting the full benefit of having secured this property. So that is my legal update for you. For more legal updates like this, you can subscribe to our channel. And I want to wish you all good luck out there, investors.